say, can't see the clock these days, but I'm a little fast, but I think it's about 10:04, so that'll give me a chance to read these cases. I will say, and it's interesting, and it just for whatever it's worth, the other side. I mean, we heard from the witness, Mr. Mercury, and it was interesting. It's all interesting, but there is one thing. These machines, this machine with this BRE, I guess it is, backed by the BVPAT, has been certified by the federal government, and even more narrowly, it's been certified by the state. And it's the accepted machine, and these code sections seems to refer to it at least.
253 B1, Your Honor.
That's right. Seems like one of these I've actually read the words that DRE stands for. I mean, it really narrows down to the question of whether there was a full recount. That's the key concept here. And, you know, Ms. Merkel, for example, and I appreciated her testimony, but she's an engineer, she knows a lot about computers. Because she's worked in the field of computers as they're used in electronic voting now, she knows something about voting, but she testifies as an expert on computers, not voting. So it's for the court to decide what the legislature had in mind when they wrote these things. But I mean, it comes down to, it seems like it comes down to a simple question. Under 19253B1, the last three words, and any full recount, that is what the contestant relies on. On the face of it, it could be argued that that means that to do a recount, you have to use the paper. The BVPAT. On the other hand, under 15267, which is apparently what the registrar of voters found, seems to suggest that it's the challenger's option to choose how they want the recount to proceed. You can either have a manual recount, or you can have a recount of the way the votes were cast, which turns out to be an electronic recount. And then it says or both. And I take it, if I hear all this at length, I'm sure, but it would be that Mr. Page's argument that, and there is a certain logic to it, that we've heard that to manually count the BVPAT votes could be time consuming and expensive, and that you got to get those out of the machine somehow. There's quite a lot to that. Wouldn't be illogical for a challenger to say, we want a manual recount of the absentee ballots. Those can be ambiguous on their face. We can get into all these issues of identifying marks, undervotes or whatever. There's something you can physically recount. We want that manual recount. And as to the electronically voted, the electronic votes, well, we think that we're satisfied with that vote total. For whatever reason, we don't think there's any big error in that or whatever, and that's permissible to do that. That's how you read 15627A. And that seems to be what's the issue here. There does seem to be something of an inconsistency maybe between the two sources. So, anything you have to offer? I mean, I've read your briefs, and there's references to legislative history and the Secretary of State's directives on this. I've read all that, and I'll read you. But I mean, that seems to be the nub of the matter as far as this, whether there's a full recount. I guess I'm just saying that because I don't think it's in this court. I think this court is not gonna engage, get involved in whether or not the system works right, or there could be a better way to do it or something. That's up to the legislature to determine that, or maybe the secretary to say, whoever certifies these things. But we're not gonna be, here in Department C-20, we're not gonna change the way these things are used here in California.
You want to